Hello and welcome to UGC channel. International law is one of the most crucial subjects given under UGC NET syllabus. Especially if I talk about theories, because there are several theories which is being covered under international law, and these are those portions which you cannot sideline while preparing for the exam. So stay connected with this video because I will be briefing on important theories which is being covered under PIL. So let's start with the basis of international law. The present-day international law owes its origin to the jurist Grotius. And emanating from his conception, there are two theories as to the true basis of international law. Right? First is naturalist theory. Second is positivist theory. Now, what is naturalist theory? Natural law, right? Natural school of jurisprudence. So they basically share the same theme. So this theory, which is naturalist theory, it emanates from God, reason or morals. According to the supporters of this theory, law of nations is only part of law of nature. Let me reiterate it. That law of nation is only part of law of nature. Right? So this is completely one of the extremist view, right? This is one of the extreme, naturalist theory. Now, if I talk about positivist theory, right? Positivism. Wherever we hear positivism, we connect with the Austin, right? But we are not talking about the Austin over here. But yes, the context is almost same. See, according to the positivist theory, only those principles may be deemed as law which have been adopted with the consent of states. So one naturalist theory has been completely depend upon the reason, upon the God, upon the morals, upon the law of nature, whereas the positivist theory is completely depend upon the consent of states. Now, after these two theories, we have also got one theory which is known as eclectic theory. Right? The supporters of this theory followed a middle position between the naturalist theory and the positivism, right? The positivist theory. Because they treated, according to the eclectic theory, they treated natural law and the positive law of custom and treaties equally. Right? So these are basically the three theories which you are going to study under the basis of international law. Right? Then there comes relationship between international law and municipal law. Let's just understand that what is the basic difference between international law and municipal law, right? So see, international law is applied in the relations of state, international organization or institution, non-state entities or individuals. Right? So these are the subjects, right? The categories which I have mentioned before you, these are the subjects of international law. Whereas if I talk about municipal law, it is being applied within a state to individuals and corporate entities. So the scope of municipal law is quite limited, right? Now, when there exists a conflict between these two systems, a court is faced with the difficulty of arising at decision. Hence, let's see the views of jurists on the question of relationship between international law and municipal law. So basically, there are two theories which describe the relationship between municipal law and international law. First is monistic theory, second is dualistic theory. So let's just go through the monistic theory. What is this? So according to this, both systems, which system we are talking about? International law and municipal law. They have their origin from one universal legal system serving the needs of human community in one way or the other. So international law and municipal rules, they are the aspects of same phenomenon, right? So they are basically derived from the same legal system. This is what it wants to convey. Hence, the substance of law is same, right, for both of these laws. What is that? That is, there is a command which is binding the subjects of law. Now let us just go through the chief exponents of this very theory. They were Kelsen, Wright and Westlake, right? Now there is one more aspect which I would like to highlight. It's a delegation theory. Please note that this theory doesn't describe the relationship. It is not connected with the theory of relationship between municipal law and international law, but it concerns with the application of international law within municipal sphere, right? So it won't be counted as the theory under relationship between international law and municipal law, right? It just only applies with the applicability of international law. So according to this theory, monists contend that each state is delegated with the constitutional rules of international law. That permits each state to determine as to how international treaties will be applicable in the field of state law, right? So please keep a note of it. The second theory is dualistic theory, according to which municipal law and international law, they are separate, they are distinct, and they are self-contained legal systems. Now, how municipal law and international law, they are different from each other. On the screen before you, you can see the table, right, which explains you like how these two systems are separate from each other according to the dualistic theory. Now, so there are basically three criteria, right? On the extreme left, you can see the three criteria, which is subjects, origin, and substance. Now, the subjects which is being covered by the international law, they are the states, whereas municipal law only covers the individuals, right? The origin, right? The next point is the origin. The origin of international law is the common will of the states, whereas the origin for municipal law, it's the will of the state, right? Last one is the substance. Substance are also different in these two laws. For international law, the substance is pacta sunt servanda, which is the promises or the agreement between the states, they are required to be respected. But in case of municipal law, the substance which is being backed by over here is the command of sovereign. So this is how the municipal law and international law, they are different according to the dualistic theory. Now let us just go through the chief exponents. They are Triple and Ancelotti, right? Now the next thing which I would like to highlight is the specific adoption or the transformation theory. Again, I would like to remind you that this theory, which is specific theory, this is not a theory which concerns with the theories of relationship, right? There are only two theories of relationship. One is monistic, second is dualistic. Whereas the one theory which we have discussed in the previous slide, which was delegation theory, and this theory, specific theory, these are those theories which tells you which is concerned with the applicability of international law within the municipal sphere, right? Now let us see what is that. So specific adoption theory, according to which dualistic contend that rules of international law won't be automatically applicable to municipal sphere, and they become binding on municipal courts only if such rules are transformed into municipal or state legislature, right? Now last one is the recognition. You know the importance of recognition under international law, right? Whether if I talk about de jure recognition or de facto recognition and the various case laws which comes under the concept of recognition, they are important. But let us just also go through the various theories which is being propounded under the concept of recognition. So the first theory is constitutive theory, which was advocated by Hegel, Ancelotti, and Oppenheim. Now let us just see that what does it convey. So according to this theory, an entity doesn't become state by possessing essential attributes of statehood, right? But an entity becomes a state when other states recognizes it or grants it, right? So this is what your constitutive theory is. Okay, so the state becomes or an entity becomes a state only when it has been recognized by the other states, right? It doesn't matter whether it is holding the attributes of statehood or not. On the other hand, we have got declaratory theory, right? And the supporters of these theory were Hall, Wagner, Brearley, and Fisher. Now let us see that what does this theory convey. So according to this, a particular state possesses the essential attributes of statehood. There is no legal duty to recognize states even after it attained statehood. Right? So it has been completely contradictory to constitutive theory, wherein under constitutive theory, the other states are required to recognize that particular entity as a state. But under a declaratory theory, if an entity has been already acquiring with the attributes of statehood, it will be declared as a state. Now the last theory is the modified constitutive theory, which was propounded by Kelsen. Now, according to Kelsen, statehood may be distinguished into natural statehood and juridical statehood. Right? So this is what he conveyed. Now let us just understand that what is natural statehood and juridical statehood. Natural statehood exists in a state from the moment it comes into a possession of essential elements of statehood. Right? Whereas juridical statehood is acquired by the state only when other state recognizes it. So it's just like more or less you can say that it is a combination of the above two theories which we have just discussed, right? This is what the important theories which is given under the recognition. There is one more update that Juris Academy is going to commence its new UGC NET batch from 20th August. Now what you will be getting? You will be getting live lectures on paper 1, live lectures on paper 2. You will be provided with a separate study material for paper 1 and separate study material for paper 2. You will be having access to 10 mocks for paper 1 and 10 mocks for paper 2, which has been based on the recent year pattern. Then you will be having unlimited access to recorded version of live lectures. So for the details of this course, do visit the link given under the description box. And all these things you will be getting at the cost of just ₹990. Right? So do check out the details of this course because the last date for the enrollment of this course is 31st August. Thank you for watching this video. If you like the content, please do like and share this video with your friends and do subscribe Juris channel to get the further updates.